Hello, this presentation is being brought to you by Jimerson & Cobb, PA. The title of this presentation is Condominium Assessments, and more specifically, the collection methods available under the Florida statutes for collecting past due assessments owed to a condominium association. And your narrator is Hans Wahl. I'm an attorney with Jimerson & Cobb, and this presentation is as of July 19th, 2013. Now, as far as the roadmap of this presentation, we'll begin with an introduction of the topic. Then we'll go over the process from initial demand letter to possible foreclosure action. We will then discuss defending associations and lender foreclosure actions. And we'll move to collecting past due assessments when unit ownership has changed hands. And this involves when the ownership has changed to a new individual unit owner or to a first mortgage holder, and that would involve a discussion of Florida's safe harbor protection under the Condominium Act. And we'll also discuss when the unit ownership has changed hands to the association itself. Maybe the association brought its own foreclosure action. And then we'll also discuss recent changes to Florida law affecting condo association assessments. All right, now, as far as an introduction, Florida courts have recognized that the Florida statutes have delegated certain governing authority to condo associations. As a result, judges have referred to condo associations as a quasi-government entity and a sort of democratic sub-society. Because condo associations have certain governing authority over its community, the power to levy and collect assessments from unit owners has been compared to a governing body's power to tax. And the annual budget will determine the unit owner's assessments for that year. Under the Florida Condominium Act, all associations each year must create its own annual budget, and that annual budget divided out by the number of unit owners will determine what the assessments are for that upcoming year. Now, assessments, they can be used for providing services to unit owners, for maintaining the common elements such as pool, clubhouse, parking lot, tennis courts, gym, elevators. They could also be used for improving the community, replacing the roof, upgrading appliances, etc. And the condo association's governing documents, which would include the Declaration of Condominium, the bylaws, and the Articles of Incorporation, they cannot conflict with the Florida statutes. Even though condo associations are considered a quasi-governmental entity in that it can create its own rules and regulations, such rules and regulations cannot conflict with the Florida statutes. And the Florida Condominium Act that you will hear me refer to, it is codified in Chapter 718 of the Florida statutes. Now, Section 718.116 of the Florida statutes will govern association assessments, and it states that a unit owner is liable for all assessments which come due while he or she is the unit owner. And it also provides the association with the right to a statutory lien. The association has a lien on each condominium parcel in order to secure the payment of assessments. In other words, the condo unit itself serves as security for the payment of all assessments. And the association has the right to place a lien by statute on that condo unit if the unit owner is not paying his or her assessments as they come due each month or quarter. And although a condo association's governing documents may allow it to issue fines, the Florida statutes specifically prohibit fines from being the basis for a lien. So if the association is going to record a lien against a unit, it can only be for past due assessments. It cannot be because there are fines issued which the unit owner is not paid for. Now, in regards to delinquent unit owners, and what we mean by that are unit owners who are delinquent in paying their assessments, condo associations have the statutory right to collect interest, late fees, attorney's fees, and collection costs. And the caveat there is as long as the governing documents allow for it. So the Florida statutes allow for it, but the condo is free to create its own rules as long as they don't conflict. And if the governing documents of the condo association, such as the declaration, doesn't specifically provide the right to collect these things, then they could be waiving the right. Now, if the governing documents allow for it, the association may accelerate the assessments of a delinquent unit owner. And what that means is, for example, if assessments are due quarterly and a unit owner becomes delinquent in the second quarter, such accelerated assessments shall include the amounts due for the remainder of the budget year in which the claim of lien was filed. And a brief warning here, for a condo association to successfully lien and ultimately foreclose on a unit, the specific statutory provisions must be strictly adhered to throughout the lien foreclosure process. And this is foreshadowing the rest of this presentation, but the Florida Condominium Act provides some strict guidelines on notice requirements, waiting periods, lien language, etc. What we will discuss right now is an overview of that process. The first step would be making the initial demand, so it would be a demand letter to the delinquent unit owner. The demand letter is optional, but it may be worth it for an association to do so. It's a low-cost way of, maybe the unit owner doesn't realize they're delinquent, and a quick demand letter will give them notice of that, and they will rectify that on their own. Nowhere in the statute does it say you must send a demand letter first, but it's a good cost-effective way of trying to collect past due assessments. Now, step 2 is the notice of intent to lien, which the statutes do provide strict guidelines on. After the notice of intent to lien, the association can file a claim of lien. After filing and recording the claim of lien, the association can send out a notice of intent to foreclose that lien, and then if the assessments still are not paid, the association can bring its own foreclosure action. Regarding the notice of intent to lien, prior to filing the claim of lien, the association must give the delinquent unit owner 30 days written notice. Now, the notice of intent to lien must be delivered to the unit owner by both registered or certified mail, return receipt requested, and also U.S. mail. So it needs to be sent via U.S. mail and certified mail. And it must be sent to the unit owner at the address of the unit, and also to the unit owner's last known address as reflected in the association's records if different than the unit address. So sometimes a unit owner may just be an investor who owns real estate and is renting it out. Well, that notice needs to be sent by U.S. mail and certified mail to both the unit and to the unit owner's address if their main address is different. Regarding the claim of lien, to be valid, the claim of lien must include the following. It must provide a legal description of the condominium parcel. It must provide the name of the record owner of the unit as contained in the public records. It must provide for the name and address of the association. It must state the amount due, and it must state the due dates. And it must be executed and acknowledged by an officer or authorized agent of the association. So it needs to be signed by an officer or agent of the association and notarized. And because association liens require a legal description and they create property rights, only attorneys may draft association liens in the state of Florida. The claim of lien is only effective for 1 year after it is recorded. And so what that means is that the association has the right to foreclose its lien, but the action to enforce the lien must be commenced within 1 year of filing and recording that claim of lien. The 1 year period is tolled for the length of time an association is prevented from filing a foreclosure action due to the debtor filing for bankruptcy and the bankruptcy code's automatic stay. The claim of lien will secure all unpaid assessments that are due and that may accrue after the claim of lien is recorded and through the entry of final judgment, as well as securing interest owed and costs and attorney's fees owed. And upon payment in full. If the unit owner does pay in full all the amounts owed, the unit owner is entitled to the filing and recording of a satisfaction of lien in the public records. Now, the claim of lien can be contested by a unit owner. A unit owner can object to it by filing what is called a notice of contest of lien. If such a notice is filed by the unit owner, the association must commence action to enforce the lien within 90 days from the date on which the association receives that notice. So, as previously mentioned, the association has up to a year to file its foreclosure action. But this is a protection for the unit owner, in that if the unit owner thinks the claim of lien is recorded incorrectly, it can file this contest of lien, which says, it's basically the unit owner saying, look, you're hurting my, you're clouding the title that I have to this property, you're affecting my credit, and you now have 90 days to enforce it, so you can't leave it hanging around there for a year, affecting my property rights. If the foreclosure action by the association is not commenced within that 90-day period, the claim of lien is voided, and the unit owner's objection is presumed to be valid, and the claim of lien is no longer in effect. Now, after filing the claim of lien, the Condominium Act requires, before moving forward, that you have to send a notice of intent to foreclose that lien. So before you can bring that foreclosure action, you must provide the unit owner notice of your intent to do so. So the way this works is, after filing the claim of lien, the association can foreclose on the lien, but not before it provides the unit owner with 30 days written notice of its intent to foreclose. The notice of intent to foreclose must be sent to the unit owner, again by U.S. mail and certified or registered mail, to the address, to the unit and to the unit owner's last known address. And the notice shall be deemed to have been given upon mailing it pursuant to the statutory requirements. So the 30 days starts from the mailing date if it is sent according to Florida law. If the unit owner records a notice of contest of lien, the notice of intent to foreclose lien need not be sent, because obviously the purpose of the notice of intent to foreclose lien is to give the unit owner notice. But if they know about the claim of lien and file a notice of contest of lien, then obviously they already have received notice of that. Now, regarding the underlying foreclosure action, the Econo Minium Act, specifically section 718.116, it states that the association may bring an action in its name to foreclose a lien for assessments in the manner a mortgage of real property is foreclosed, and may also bring an action to recover a money judgment for the unpaid assessments without waiving any claim of lien. The association is entitled to recover its reasonable attorney's fees incurred in either a lien foreclosure action or an action to recover a money judgment for unpaid assessments. The association has the power to purchase the condominium parcel at the foreclosure sale and to hold, lease, mortgage, or convey it. And during the time the association owns title to the unit, it must pay the assessments that come due in the same manner as the other units. So what this means is that an association has two ways to try to collect the money that's owed to it. It can foreclose on the property, and if it forecloses on the property, it can gain title to it, and it is then free to rent it out. It may be subject to an underlying mortgage. In that case, it wouldn't own it outright and clear, but in some situations there may not be an underlying mortgage, and in that case the association would own the property outright, and in that case it could sell it as a way to recoup all past due amounts owed and even possibly make some additional money. And it can also seek a money judgment against the individual. So basically the failure to pay assessments is more or less it's a breach of contract because by closing on the unit and having the deed of the property granted to that unit owner, he is now in contractual privity with the association for the payments of dues as called for under the declaration. And so the association can bring an action for a money judgment against that individual to recover the amounts owed. Oftentimes, the association will find itself a defendant in the lender's foreclosure action, and that is because when a lender files a foreclosure action, it must name everybody who might have an interest as a defendant, and the association obviously has an interest in the property, and so they are named as the defendant. And if unit owner, so the way this works is if unit owners aren't paying their association assessments, they are probably not paying their mortgage either, and the result is the mortgagee filing a foreclosure action and naming the condo association as a defendant. And there are considerations to take into account when defending the association, such as, are the ongoing assessments currently being paid by the tenant? Because there could be a number of situations. This could be a situation where the unit owner is an investor and isn't paying the mortgage, but in that property there is a tenant who, in addition to paying the rent, is paying the assessment. So the association is still getting paid, but the mortgage company is not. So here you have the mortgage company has the interest of and the motivation to foreclose quickly, but the association may not want that to happen because there's a tenant in there that's paying the assessments each month. Now we'll move to discussing collecting the past due assessments when unit ownership changes hands. So here, what if a new unit owner occupies the unit while the previous owner's past due assessments are still outstanding? Well, there are three different answers and or approaches based on whether the new owner is one of the three entities, whether it's the individual, whether it's a mortgage institution, or whether it's the association itself. Now, if the new owner is just another individual, the prior owner sold the property to the new owner, but there was outstanding assessments, the Florida Condominium Act is clear that a unit owner is jointly and severally liable with the previous owner for all unpaid assessments that came due up to the time of title transfer. The unit owner is also solely liable for all assessments which come due after he or she has become the unit owner. So this new unit owner is jointly liable for the past unpaid assessments and is now responsible for all future assessments. The new unit owner, however, is able to recover from the previous owner the past due assessments, but it's up to that new unit owner to make that demand and maybe even file suit if necessary against that prior unit owner. But as far as the association is concerned, the new unit owner and the old unit owner are both liable jointly for the past due amounts owed. The association can go after either one. It can't recover the same amount from both. It can't get a double recovery, but it can go after the new owner or the old owner for payment in full. And the condo association, in making its demand, can actually, as we'll discuss later on, suspend use rights to the common elements if past due assessments are not paid in full. Now, if the new unit owner is actually the first mortgage, the holder of the first mortgage, so it's a bank or some type of financial institution, the Florida Condominium Act provides that the first mortgagee, its successor, or assignees have their liability protected by what is called the safe harbor provision of the Florida Condominium Act. And this limits the liability of that institutional first mortgagee to the lesser of the unit's unpaid and outstanding assessments for the prior 12 months or 1% of the original mortgage debt. And this is simply to protect the mortgage company. There may be situations where past due assessments over the course of years add up to $20,000 and the unit owner is not paying the mortgage either, so the mortgagee forecloses, takes title to the unit, and if it weren't for this protection, they would have to pay that entire $20,000 amount. Now, obviously, whether you're for or against that depends on what side you're on. If you're on the side of the association, then that's not a good thing. If you're on the side of the institutional mortgagee, then it is a good thing. It just depends on how you look at it, but the law is what it is, and that's what it states now, that if the first mortgagee forecloses and takes title to the property, then its liability is simply the lesser of the prior 12 months of unpaid assessments, or 1% of the original mortgage debt. Now, how does this play out? Just as an example, if we're talking about the mortgage company that gains title to the property and its liability is restricted by the safe harbor, as an example, let's just say the unpaid assessments were $200 a month, which comes to $2,400 for the prior 12 months. Well, if the mortgage was originally for $180,000, 1% of that is $1,800. So the first mortgage holder is only liable for the lesser of the two, which will be $1,800. So that is the amount that the first mortgagee is responsible for paying to the association once he gains title to the unit. And in order to receive this safe harbor protection, the mortgage company must have joined the association as a defendant in the foreclosure action. If it fails to name the association as a defendant, then it's not entitled to this safe harbor protection. And the safe harbor applies only to past due assessments. The first mortgage holder must now pay all future assessments incurred while it has title to the unit. So this protection is only to protect the mortgage company from the prior balance owed. But once it gains title to the property, it is now responsible for paying all future assessments as they come due each month. Now, if the new owner is the association, which means that the association brings its own foreclosure action based on its lien and forecloses and takes title to the property, an association that acquires title to a unit through the foreclosure of its lien is not liable for any unpaid assessments, late fees, interest, or reasonable attorney's fees and costs that came due before the association's acquisition of title. But the association is responsible for paying all future assessments incurred while it owns title to the unit. Now, recent changes to Florida law that affect the collecting of past due assessments, the association is actually now able to attach the tenant's rent. So the way this works is an association can require that a condo owner's tenant pay rent directly to the association if that unit owner is delinquent in paying his or her past due assessments. So let's just say that for whatever reason the unit owner is not paying those monthly assessments. The association can make a demand of that unit owner's tenant and saying you are now required to pay all future rent to the association until those past due amounts are paid in full. And then once they're paid in full, you can now send your rent to your landlord. And this law provides a form demand letter that can be sent to the tenant. And the tenant, once it receives this letter, is obligated to pay its rent, his or her rent, to the condo association until those delinquent assessments are paid in full. Now, the tenant is protected by the Florida statutes. The tenant is immune from any claim by the landlord from the time the association made the written demand to the tenant. So what that means is the unit owner cannot evict the tenant on these grounds. So the tenant must send its rent payments to the association in this scenario, and the unit owner cannot evict the tenant for doing so. And there has been some changes to the Florida Condominium Act regarding the suspension of a unit owner's amenity rights. Well, an association can suspend the right of a unit owner to use the common elements if the unit owner is more than 90 days delinquent in paying assessments. Now, voting rights can also be suspended. And there is no hearing is required for suspension as a result of unpaid assessments. However, the board has to approve suspensions at a properly noticed meeting. And the suspended vote does not count toward quorum requirements or a vote required to approve an action pursuant to the governing documents. But the board must send a written letter informing the unit owner of the suspension of rights. And a really good change to the Florida Condominium Act, or it's actually not the Florida Condominium Act, but it's to a statute in the sections involving real property. Associations that are named a defendant in a lender's foreclosure action can now expedite the foreclosure process, and this is a good thing. Associations can now move the mortgage foreclosures forward by filing a motion to the court requesting an order to show cause. A hearing is not required for such a motion. You just file the motion, and the court will schedule what it calls a show cause hearing, and that order is then sent to all parties to the foreclosure action. And at that show cause hearing, they must show up and explain why a final judgment of foreclosure should not be entered. If there's no reason why it should not be entered, if all the defendants have been served and defaulted and there is no reason why a final judgment should not be entered, then at the show cause hearing, the final judgment will be entered for the mortgagee. Previously, before this change, only the plaintiff could request the order to show cause. Now defendants with a lien interest in the property can do so. The parties who receive the order to show cause have 45 days in which to file a defense to the foreclosure. If a defense is acceptable to the court, if a defense acceptable to the court is not received, a final judgment may be entered immediately and the property set for foreclosure sale. The reason why this was a good change from the perspective of the association is that the average number of days for a lender foreclosure action before this change was nearly 900 days. So you're talking about 3 years. And almost all the properties subject to a foreclosure action were either abandoned or occupied by a unit owner who remained delinquent through the entire foreclosure process. So in this situation, you can imagine past due assessments have racked up to, in some instances, 20,000, 30,000. And the lenders simply just did not push these actions forward in a timely manner because they didn't want to recognize the loss on their books, or they didn't want to be in the property management business, now owning all these condo units, which included paying taxes, insurance, and association assessments. They just didn't want to be in that position, so they really just never moved these matters forward, and it was the association who suffered. But and as a result of that, the association's budget had prolonged deficiencies, and they would have to be made up in the subsequent yearly budget by the other tenants that were in good standing. So this actually punished the current tenants. And these pending foreclosures kept housing prices depressed as well. So what ended up happening is you had these prolonged foreclosure actions going on nearly 3 years, which placed many associations in poor financial condition. However, this new procedure now allows associations to have more control over lender foreclosure actions, and they can speed this process up. And that will conclude this presentation, and I want to thank you for your time. And on behalf of Jimerson and Cobb, thank you for your participation and for reviewing this presentation.